Ken always cuts me off when I go too long, so you gotta tell me to shut up.
Sounds good. Welcome everybody to this week's JUMPinar. We're just gonna sit tight for a minute while people start joining in, and we'll get started.
How many people have gone before me today? You
Oh,
started around,
just you today.
oh, just me?
Mhm.
Oh,
All right, everybody. We're gonna wait another minute or two while people start finishing up joining in, and then we'll get started. So hang tight. All right, looks like our attendees have leveled off, so we'll get started here on tonight's JUMPinar. Thank you everybody for registering and joining us tonight. Tonight we have Jeff Michels talking about the ABCs of LLCs. But before we get to that, I'm gonna do a little housekeeping on our functions here on Zoom. As the presentation goes on, if you have any questions, you can use the Q&A function. If you hover your mouse onto the bottom part of your screen, it should show a toolbar, and you can click the Q&A button and type all your questions in, and Angie and I will go through them and bring them up when they're relevant, or if they're more general questions, we'll save them toward the end. Other than that, we don't have any polls tonight, so I don't need to go over that, but we have the chat disabled for now, and afterwards we'll do a little networking session at the end, and we'll open up the chat and people can connect with each other or reach out for any inquiries if they have them. But yeah, I think that's it. Angie, is there any updates with Jumpstart?
Just for anyone who may not have joined us for other JUMPinars, just want to remind you that we are lending. We've closed on several loans in the last few weeks, and today I think was a record day for loan applications. We received about 7, maybe even 8 applications today, so keep those coming for both Jumpstart Germantown and Jumpstart Philly. And if you have any questions, just you can email me, and I'll put my email in the chat. Thanks.
Great. Thanks, Angie. All right, so
can I ask you a question?
Yeah, sure.
Do you want me to limit this to LLCs or normally what I speak about?
Yeah, you can speak about whatever you please. Sure.
All right.
All right, so without further ado, I'm going to introduce Jeff here. Since 1987, Jeff has provided legal counsel to individuals, estates, corporations, closely held businesses, and real estate developers, building long-term relationships based on integrity and high-quality service. Clients of all types and sizes trust his many years of experience and guidance in estate planning, estate administration, corporate and real estate transactions, and contract issues. Jeff was raised in Northeast Philadelphia and now resides with his family in Bucks County. He has served as an arbitrator for the Bucks County Court of Common Pleas and as an arbitrator for other attorneys in alternate dispute resolution forums. He also frequently sits as a judge pro tem for the Philadelphia Court of Common Pleas. Active in his community, Jeff often lectures on personal injury matters as well as corporate and real estate issues for various businesses and nonprofit organizations. He is a member of the Bucks County Chamber of Commerce and also served up for many years as a volunteer coach with the Council Rock Basketball Association. So thanks for joining us tonight, Jeff. I'm going to hand it over to you to get started on your presentation.
Hello, everybody. I wish I could see you. This is very, very strange for me because I like to look at people face to face, and I am going into the 21st century screaming and kicking, but I'll do what I can, and hopefully it'll be enjoyable and it'll work out for you guys as well. I always start by one important caveat or something to think about. And because I've seen this over the years, you're getting involved in real estate investment, and especially when you're looking at your first deal and you're anxious and you want that deal, you want to jump on it. you gotta be willing to walk. You gotta be willing to know if the numbers don't work for you, there's gonna be another deal down the line. So be patient, do your legwork. The numbers work, great. If not, be willing to say no. I know you're anxious, but be willing to walk away and say, okay, this isn't the right deal. There's going to be another one. Okay. Investing in real estate is all about risk. There is no way to eliminate that risk, but you can lessen the risk, or at least have the opportunity to be aware of what risk you have out there, appreciate it, and then you'll be able to make more intelligent decisions with regard to whatever specific deal you're contemplating. The more you know, the better your chance of success. And the best way to start is to understand there are going to be some legal documents involved. Okay, these documents lay out your risk, your obligations. They lay out your legal rights, and hence this is a great way to determine what risks are out there for this deal. Good rule of thumb: if you don't understand something in the document, ask. Don't assume anything. Don't assume that the documents are all standard. They're not. In the world of commercial real estate, the documents can vary dramatically. In residential real estate, they're going to be much more similar, but there are still protections in these documents that are key to the buyer. Okay? And whether it's a commercial property or residential property, there's several things to look at in your agreement of sale. One is a mortgage contingency. What is a mortgage contingency? You are buying a piece of property, and what the agreement is saying to you is, if I don't get a loan for a certain amount of money, then I don't have to buy the property and I can get my deposit back. Okay, that's a very, very key protection for a buyer. Look at the mortgage contingency. And when I talk about if the numbers don't work, there's going to be an amount in there. Well, you got to make sure that this is the amount I need in order to purchase this particular property. There's going to be an interest rate cap. And you got to say, well, if it's at 5%, I can do it, but if it jumps up to 6 or 7%, now the numbers aren't looking so good. So you want to make sure that that cap is within your number structure, within what works for you. You're going to see inspection provisions, also very, very important. It always boggles my mind if somebody's about to put down, whether it be for the private residence or for an investment, they're about to put down more money than they've ever thought they were going to put down, but they want to go shy. They're not going to spend the other couple $100 on an inspection. These are things, again, to help minimize your risk. What is an inspection? They're going to check the electrical system, the plumbing system, the roof, all of those fun things. To know what kind of condition this property is in. The more you know, again, the better position you're in. The inspector, just so you understand, is typically not going to guarantee anything. They're not going to say, well, I guarantee you that there's no other systems in this property that are bad or going to go in 2 years or whatever. They're not going to guarantee anything. So why get an inspection? You get an inspection so you know. So you have your eyes open and you have a good idea what you're getting into. You don't want to walk into a deal and then the next thing you know, you're dishing out money for a whole new heating system or a roof, things like that. You want to go in with eyes open. Liquidated damages provision, a very small thing that a lot of people miss. You'll see, especially in the residential area, there's a little box you can check that says your deposit is your liquidated damages. What does that mean? For whatever reason, you have to walk away from the deal. And I'm talking about not walking away from the deal because you didn't get your mortgage, or walking away from the deal because the inspection isn't to your liking, but the last minute you have to walk away from the deal. You default on the deal. What a liquidated damages provision says is all they can do is keep your deposit. They can't sue you. They can't say, well, I had to keep the property off the market for 3 months and come after you for opportunity costs, what they call it. It is another way of, again, limiting your risk. Another good rule of thumb: don't assume anything. If it's not in writing, you don't have it, okay? You think, I'm buying this piece of property, I love that chandelier in the dining room, and that'll be a nice addition. And then you go to closing and there's a big hole where the chandelier was, or whatever it is. That's just an example. Get it in writing, okay? That's an agreement of sale. That is usually the first document you're going to see. Loan documents are important. And I know that there's going to be other people probably to talk about the banking end of this, but these are also important. And again, remember that rule of thumb. If you don't understand something, ask somebody to explain it to you, okay? Loan documents, promissory notes, mortgages, rental assignments, personal guarantees, and often many, many, many more. These are documents that are going to say, this is a very key to the risk you're taking on with buying a piece of property. Go through it, have it explained, know what's there. Make sure, again, that the interest rates are what you think they are. Make sure you look for something as simple as a prepayment, if there's a penalty stuck in there. Because you're hoping to pay this off, in 6 months and not a year or 2 years or 3 years. Make sure that that's not going to cost you. Read the documents, understand the documents, ask your questions, get help if you don't understand it. Just as important as your investment that you're putting out to buy the property, and potentially even more devastating, is the risk of litigation. I don't believe that I'm going to be telling anybody listening to me right now anything that you don't already know, and that is we live in a very litigious society. First time somebody slips on your sidewalk, first time a contractor hurts himself in the job, they're going to be in an attorney's office looking to sue. Whether or not it's truly a viable claim or something that you think is a bunch of what, it's not only time consuming, but it can be extremely expensive. So another key to controlling that risk is to make the right decision in how to purchase your property. Form a company. Usually what is being used most often in today's world is limited liability companies. Back many, many years ago, you would see limited partnerships. They're still around sometimes, but usually you're going to see a limited liability company. What is the purpose of forming that entity? You're not forming that entity for any tax benefits. It's not giving you any tax benefits. But what it is doing is it's giving you that wall of protection between you and the outside world. And when I say you, I mean you, the individual, the person, okay? So that if somebody slips on the sidewalk, who are they suing? They're suing Joe Smith LLC or Real Estate Investors LLC, as opposed to Joe Smith, as opposed to you, so that your personal assets, your health, your cars, your bank accounts that you've worked so hard for leading up to that point are not exposed, okay? There are exceptions to that protection. Just so you know, as I say, there's certain people that it's their ball, it's their rules, so they set the terms of the game, and that is, for example, banks and landlords. Banks won't have a problem lending to an LLC, and they know why you're forming it, because you're forming it for liability protection. But they're going to want a personal guarantee. Their ball, their rules. That means that they'll lend the money, but they want a personal guarantee. Landlords, the same. Landlords will lease to a corporation, to an LLC, but they want a personal guarantee. And a heads up, if you're planning to buy a piece of property and hold on to it and lease it, and you are the landlord, and you're leasing to an entity, a liability company, corporation, whatever it is, you're the one that's going to want to get that personal guarantee from the people that own that entity, because the entity might not have a lot of financial wherewithal. You're lending based upon, or you're leasing based upon financial prospects of the people that own it. So it's only good if you get that personal guarantee. An LLC is a key tool to do it. But you have to, and this is something that often gets missed, you have to operate as an LLC. Or there is what they call piercing the corporate veil, getting through the entity, limited liability company or corporation or limited partnership, and getting to the individuals. It's very simple. You're signing a document, signing an agreement of sale. You're not signing it as Jeff Michels. You're signing it as Jeff Michels, member of Investors LLC or president of Investors LLC. So that I know as a seller or whoever is the seller, you're dealing with an entity, okay? Separate bank accounts. You're not going to commingle the funds from the limited liability company with your personal bank account, okay? That is a key no-no to saying, you're not really doing business as a limited liability company. They're small things, but they're good things that if you ever, end up down that road, you can show, no, I'm doing everything appropriately. My individual dealings are different than my limited liability company. Very, very important. If you're going to buy a piece of property in an LLC or other entity, like I say, most people are using limited liability companies, you want to buy it from the get-go in that company. You don't say, well, I'll buy it in my name, and later on down the road, I'll transfer it to my limited liability company. Because what it is, even if you are an individual and you own 100% of that limited liability company, you have another transfer. You have another transfer tax. In Philadelphia, that's over 4%. So you're paying all that money. If you would have put it in the LLC from the get-go, you're not going to deal with that, okay? I get the question all the time, I have two pieces of property in my name and one in my husband's name. I want to transfer it into an LLC. Don't, because you're just paying a transfer tax for nothing. I'd rather see you take that money, go get a nice $1 million, umbrella policy for the properties and use it that way, because you don't want to have to just pay a transfer tax for no reason.
Jeff, I have a question from Patrick here. What is the transfer tax in Philadelphia? Do you know the number?
It's it just went up 4.1%, I believe.
Great.
So it's much higher than outside of Philadelphia.
Okay, great, thanks.
Okay, and typically that's going to be paid half by the buyer and half by the seller, but you don't want to, if you're transferring it from you, the individual, to your LLC, you're paying it all because it's just you. So you want to buy it in the name of the LLC to begin with. Let's say you're thinking about flipping the property. A lot of times what people used to do is they would buy the piece of property in their name and they would put, or their assignee, so that they could flip the agreement of sale into an LLC, for example. The problem is that Philadelphia has taken a very aggressive approach recently, and they're saying that transfer, even though you've never taken possession, you, the individual, have not taken possession of that property, when you transfer it to a limited liability company, they're deeming that a transfer. So you've got a transfer tax when you really haven't done anything. Now, there is a way around it. There is what people have been using is what they call a novation. A novation has to be agreed upon by the buyer and the seller from the get-go. And what it is essentially is that you are agreeing to terminate the original agreement of sale. So that is null and void. And then enter into a new agreement of sale with the entity, okay? That has been upheld, that's been fine, but you got to get the seller to agree to that up front, because once you terminate an agreement of sale, it's free game. They could say, I got a better buyer, they're paying more than you. That's why it has to be upfront in the agreement that you are able to do an ovation if you decide to do it. But avoid all that, put it in the LLC from the get-go, okay?
So just sorry to interrupt. I just have another question from Antonio here. In what events, if there are any, would an LLC provide more protection than a $1 to $2 million umbrella policy?
having an LLC does not alleviate the need for insurance, okay?
Okay.
Because insurance is giving you a couple things. Having an LLC, there's still exposure there, and we're going to talk about that in a second. But the exposure is, and the protection that the limited liability company is giving you is protecting your personal assets. You cannot protect, just having an LLC is not protecting the equity that is in that limited liability company. So if you bought a piece of property and you put down, you know, $50,000, whatever it is, if somebody falls and sues you, sues the LLC, because the LLC owns the property, you, the individual, have nothing to do with it other than you own the LLC. I can still, if there's not enough insurance, I can still get at the equity of what that LLC has. But what I can't get at is your personal assets, your personal bank account, your house, your car. That's where the wall protection comes in, okay? Insurance, you still need for a couple reasons. Number one, you don't want to expose the equity that you're building up in this company, okay? Number two is one of the things you get when you buy an insurance policy or liability insurance policy is representation. And if somebody sues you, the insurance company is going to provide an attorney, and they're going to pay the cost of that attorney. That's one of the protections you get when you have an insurance policy. They're expensive, I can tell you. So it's just having an LLC. It's giving you that wall protection from your personal assets, but it does not alleviate the need to have insurance, okay? With that in mind, you have an LLC, you bought your first property, and everything's going great, you find your second property. Do you need to put it in a separate limited liability company? This is a question that's all about risk. If you buy that second property and you put it in the same LLC, then whatever equity you have built up in the first property is exposed to any liabilities on the second property. So if I fall at the second property and I sue the LLC, which now holds two properties, any equity that's in there, over and above insurance, of course, I can potentially get at, okay? So what do you do? If you're starting out and you're buying small properties, you know, the smaller properties, remember that first, you might have very, very little as far as equity in those properties because you're taking out a loan and what you're actually putting down is very little. You don't need to form a new LLC for every property. I can tell you that I have clients that might have an LLC that has 10, 12 properties in it, okay, if they're all smaller and the equity is only so much. Now you've stepped up, you're doing great, you know what you're doing, and you decide, okay, I'm not going to buy that, you know, $100,000 or $80,000 piece of property. I'm looking at something that's much more expensive, you know, $300,000 to $500,000 piece of property. You might want that because you're going to put down a lot more from the get-go. You might want that in a standalone LLC and something that has nothing else in it, so that the only thing that is exposed is that property itself, okay, as opposed to putting it in with the 10 other properties that are in your first LLC and exposing that big chunk of equity on this new building to the potential liabilities on those other properties. But it's a personal decision. When do you feel that you have sufficient equity that I'm going to form the second LLC or third or fourth? What you feel and you're comfortable with might not be what the person next to you is comfortable with. I don't think that especially when you're starting up on smaller properties, that you need to form a separate LLC for each property. Number one, there's an upfront filing fee, okay? It's not a lot, but there is. But you start to get into a bookkeeping nightmare because each LLC has to have its own bank account. Each LLC files its own tax return. So the accounting fees can start adding up. So you got to look at it and you say, okay, I've got, $10,000, $15,000 of equity in this first property. I found second property. Do I really need to form second LLC? I wouldn't do that at those numbers. But as you start to grow, because remember, you're going to be paying down your loans on the property. As the equity starts to grow, then at some point you might say, you know something, I've got 4 properties, 5 properties in the first LLC. I want to go to a second limited liability. Or, as I said, you decide to buy, you're stepping up, you decide to buy a much more expensive property, which is going to cost you a lot more money up front to put down, and you might not want to expose that to some of the smaller properties. So, but that's a personal decision. Nobody's right, nobody's wrong. Look at it each time you're looking to buy a new property, reconsider and decide what you want to do. Okay. Having an LLC, as I said, does not alleviate the need for insurance, but so it does. It's very important to still have insurance. What the LLC is protecting is not what's inside that LLC. It's everything that's outside the limited liability company. Okay, because as I said, you built up a bank account and you're not hoping that that's not getting exposed, and that's why you're doing the limited liability company. We've talked about some of the risks. There's another risk that I don't want to understate, and that is when you get involved with other people, when you get involved with partners. Okay, and I hear, oh, this is my best friend since kindergarten. All the more reason that you want to have upfront conversations. You want to be able to discuss what you are each expecting from the other, or if there's more than 2 partners, and that brings in something I'll talk about in a second. What you're expecting from everybody. What you really want is if you can find partners that complement each other. You might be the financial guy, and they might be what I call the sweat equity. That they're the ones that are out there pounding the pavement, and they might know more about the construction end or the things like that. And you are the money man, so that would be a nice compliment. If you're both the money man and you're neither one of you are expecting to, you're both working full time, neither one of you are expecting to be the one out there pounding the pavement, that's going to cause a problem. Okay, I've seen that in all kinds of lines of work, and it's not just real estate, where somebody opens up, a small delicatessen, and they're each thinking that the other guy is going to be working, the 70-hour a week that requires, and all of a sudden, boom, nobody's there, and that's a problem. Okay, there are documents that partners can have between themselves. In the limited liability context, you will see something that is called an operating agreement. An operating agreement talks about the management of the entity. All limited liability companies require an operating agreement, but if you're just you and you're 100%, you read it if you can't go to sleep at night. Okay, but when you have a partner, now it becomes very important. Okay, as with bank docs, as with the agreements of sale, read them, understand them. It becomes even more important when you have more than 2 parties. Okay? If you have 3 partners, members in the limited liability company, for example, what decisions are going to require unanimous consent? What decisions are just going to require majority consent? And you got to be careful with that, because you get in with 2 guys and you look at the agreement and it says everything just requires majority consent, more than 50%. Well, that's wonderful, except you have the potential of 2 people locking you out. So you might want to say, no, these important decisions, when we invest in real estate, when we decide to sell, things that are more important than the day-to-day operations, require unanimous consent. So nobody can lock you out. Of course, if you're the one that holds 90% and the other two guys hold 5% each, you're not as concerned about that. You'll be very happy with majority consent. But what is important is to read the document and know what your rights are, what their rights are, and it's there, okay? There's other types of agreements between partners, like a buy-sell agreement. Buy-sell agreement is what happens with an asset on certain triggering events. If I own 50% of a limited liability company and you own 50% of a limited liability company, we picked each other. You want me as your partner, I want you as my partner. Well, guess what? An interest in a limited liability company is inheritable by your heirs. So if I die, now you got my wife as your partner. Trust me, you don't want that, okay? So you want to talk about, well, what's going to happen if one of us dies. I want, if you die, I want to be able to buy you out. So I don't have your heirs as my partner. And of course, you want to have your heirs reap the benefit of all the blood and sweat that you put into this limited liability company that was now built up. So we come to an agreement of how we could buy, I would be able to buy your estate out, they would sell to me, everybody's happy. What are other triggering events? Disability. What if I become disabled? I'm here working and you're expecting me to be working. And if I become disabled and I can't do that, do you have the right to buy me out under that circumstance? Bankruptcy, biggie. Because if I end up going bankrupt, and now you have the trustee in bankruptcy as your partner, that is something I can assure you you want to avoid. So maybe that's a situation where you're able to buy out my interest. So these are things that a buy-sell agreement. Another thing is it would prevent you from, or prevent me from selling my interest. Again, I want you, you want me. If I'm able to go sell my interest to Joe Schmo down the street, well, that's not, you don't want that. You don't want him as your partner. So there are restrictions. That's something that is addressed in those documents. And again, all these things can be addressed. When you start out as a buy-sell agreement, a necessity? No, because in most situations, all you have is debt to start with anyway. So there's not much to discuss, there's not much to fight over or anything like that. But it's something to keep in mind that as you are progressing and as things are looking better and better and you're understanding the real estate market and you're buying great properties and everything is going well, that you want to sit down and talk to your partner about. But have conversations with your partner about what you expect of each other from the get-go. And if you're friends, it makes it even more important. Okay, I've seen too many friends that don't speak to each other because of bad partnerships. Something to keep in mind.
Jeff, if you don't mind, I'm going to ask a couple questions here from the attendees. Yep. So this is about, partners in an LLC. Someone's asking, can they make a family member an unpaid employee or director of an already formed LLC? And if they're the sole owner of the LLC, is the brother or their brother-in-law is going to help them out? Do they need to file any paperwork or?
No.
Okay.
No, they don't. What you're saying is you want brother-in-law to help you out, but brother-in-law is not going to be an owner?
No. It's just going to be an assistant to the operation of the LLC.
Right. You can hire people just like any other entity can. Okay?
Right.
Like a corporation can. You can hire people. You can pay them, not pay them. If he wants to work for free, great, wonderful, yes.
And
no problem in doing it.
And the paperwork comes into play once you bring an owner into it.
When you bring in another owner, then you need to issue membership interest. They need to sign on to the operating agreement. So that's when you need to update your paperwork if you're going to bring somebody in as an owner. But I have many a situation where, for example, a husband owns the LLC, or I don't want to be sexist, the wife owns the LLC. But the wife wants the husband to be able to go to the bank for her and puts them on, just as an employee, or that's all you have to do. By the way, it brings up an interesting point. I always recommend, especially if you're dealing with husband and wife situations, and I know this is a very, very conservative approach, but from a liability protection, husband and wife are going into the real estate investment together. They decide to form an LLC. I always recommend that either the husband or the wife, but not both, own the LLC. The reason not both, and I always have to explain this typically to the wife, the spouses, it's still a marital asset, so it doesn't matter. But why do I recommend that? In the rare event, and I do want to express that it is a rare event, that somebody is able to pierce that veil of the LLC, as I said, pierce the corporate veil, get to the individuals. If just husband owns it, the house that you usually have in joint names, the bank accounts that you usually have in joint names with your spouse, they can't be touched. Husband and wife in Pennsylvania are looked at differently than husband or wife. So it gives you that extra level of protection. I always recommend that. And people say, oh, we both want to be involved. You can both be involved, but just take that extra little level of protection and don't put both spouses on. Okay, because if you put both spouses on and they pierce the corporate veil, they get to the shareholders. If you get husband and wife, now those assets that you hold jointly with your spouse, the house, the bank accounts, now they're fair game. Okay. Having said all that about the paperwork with partners and all that, understand these are pieces of paper. That's all it is. Nothing replaces picking a good partner. So the more you talk, the more you're on the same page with what is expected of each other, I think the better chance you have for success. When you are trying to limit your risk, as I say, in real estate, there are certain pieces to the puzzle. You're going to put a team together. It doesn't happen overnight, but it will start to happen. You'll see. The team is going to include your accountant, okay? Because they're not just there to do your taxes at the end of the year. They're there to advise you. An attorney, an inspector, a banker. All these players have a piece in your success or in different aspects of the deal. So you want to put these people together. They will help you with things. I'm not a banker. I'm not an accountant. I would tell you, you come into me, I said, get yourself a good accountant. They'll help you. So it's important to get that team together, people that you can talk to, that you can pick up the phone and say, hey, Jeff, this is a situation. What do you think? Okay. Very important to do. But as I said, there's no way to eliminate risk. What you want to do is you want to reduce it as best as possible. And most importantly, at least have your eyes open to what risks you're taking so that each deal you're in better standing to have a better chance for success.
Jeff, I have a little bit of, or a couple follow-up questions to that discussion about husband and wives. Darren wants to know, what are your thoughts on a husband and wife owning two different LLCs and partnering to buy a property?
Again, partnering to buy one property.
Yeah, that looks like the question's framed around one.
Yeah, I wouldn't go. I would have one or the other LLC buy it.
Okay.
Because if they can pierce the veil of those entities, they got both of you. And if they got both of you, that means all those joint assets that you hold are exposed. And I don't want to be gloom and doom. It's not, if you follow the proper steps that I talked about earlier, that you keep your accounts separate, you hold yourself out as an LLC, you maintain your LLC book, you have an operating agreement. It is not that easy to pierce that veil. But if there's an extra level of protection that can be afforded to you, you might as well. If it was just in husband's name or the one LLC and he buys it, doesn't change the fact that that's a marital property. Okay, so if things go sour, it's still a marital property, and it wouldn't make a difference if wife was on it or not.
Okay. I'm just going to go through some of these questions here that have been piling up over the past 20 minutes or so. Sean wants to know, he bought land in his name but hasn't put a structure on it. Is there an issue with transferring it into the LLC's name before building a house on it?
Well, you're still going to have whatever the value of that land is. You're going to have a transfer tax.
Okay. And another...
Now, you could have, when you go to put the structure on it, you can form an LLC to own the building, and that LLC would be, essentially renting from the landowner. You can do that. It'll give you some protection. But anytime you transfer a piece of property, whether it is a structure on it or not, you're subject to a transfer tax. And if it's Philadelphia, like I said, it's over 4%.
Okay. And relating to transfer taxes, Hal wants to know, even if you're transferring from one LLC to another LLC, there's still going to be a transfer tax associated, right?
Absolutely. Yep.
So here's some of the basics here. Is a regular person able to start an LLC, or do you need the assistance of a lawyer to set up the paperwork?
No. You can go on to the Pennsylvania Corporate Bureau's website, and what you need, do I recommend it? Yes, because an operating agreement is not a simple agreement that you're going to be able to just put together. I don't know what's out there, in the internet world. I've never really looked. But to form the LLC itself, no, you can do it. It's following what they call a certificate of organization with Harrison.
Okay.
So there's no magic to it. It's just when you start to get into putting together a good operating agreement, that's where an attorney is going to be more valuable.
Okay. So when you actually are setting up that LLC, is it okay if you use your home address, or should you get a PO box?
Yeah, well, you can't have a PO box.
Okay.
An LLC needs a hard address. I'm not
Okay.
sure why it needs a hard address. I hate to tell you this. They require a hard address because that way it gets sued, they have an address to serve.
They know where to find you.
Just because most people put a home address. Just because the home address is on there doesn't mean that you're exposing your house to any liability. Doesn't mean that at all. Now, if you have a real disgruntled person, they could go on the corporate website and find out what the address of that LLC is. But I've never run into that as a problem in 30-some years.
Okay. So as you're starting to explain this a little bit, we're getting a lot of questions about, the basics of when you're initially starting it, some of those critical decisions.
Yeah, I like this when I like to be there because everybody crowds around
Right.
and asks me questions,
Right.
but I get to talk to people. I can't shake hands anymore right now, unfortunately, but I get to talk to people. This is great.
Well, I'm grateful we're able to do this. So moving on, SL is asking, how much do you have to pay to set up an LLC with a lawyer? What sorts of state fees or attorney fees should they expect?
Well, I guess it depends on the attorney. I can tell you, me personally, what I typically charge is $600 plus the filing fees. But as a courtesy to Jumpstart, I discount that to $400 plus the filing fees in the book. And that comes out to about $200, depends on what the book is these days, $240, something like that. So, all told, $640. And that, for me, I'll take a soup to nuts. In other words, I'll form the LLC, I'll prepare your operating agreement. You need the LLC needs its own tax ID number. So I would get the tax ID number, put the book together, explain the operating agreement if there's any nuances. Like I said, if it's more than one person in the, usually if it's 3 people or more, sit down and talk to you as to what you want to do as far as majority or unanimous consent. So there are some advantages, but it's, so what I charge for Jumpstart people is $400 plus the filing. Okay,
great. Sean wants to know, how does forming an LLC work if you want to buy a property that's out of state?
It doesn't matter. You can still own it through an LLC in state.
Okay, so there's no distinction to say buy a property in New Jersey.
not have to form the LLC out of state. Now, what you may have to do is if you're buying a piece of property outside of the Commonwealth of Pennsylvania, depending on which state you're buying in, you may have to file what they call to qualify to do business, okay? And what qualify to do business is just a form that you file in, New Jersey or New York or wherever it is, and it says you're doing business in their state. Your Pennsylvania corporation or Pennsylvania LLC is doing business in their state, and the reason, again, that they do that is you need to have an address for service of process if somebody wants to sue you. Now, you're buying a piece of property in New York or Texas or wherever it is, and you say, I don't have an address. I don't have a physical address there at this point. There are companies out there that serve as your registered agent, and they will actually serve, this is the address that they have for Texas. This is the address that they have for New York, so that you use their address. I think it costs usually about $100 a year for their service. So it's not all that expensive. I have clients that have, businesses in Texas and businesses in California and businesses in, Washington State, and they have served, I have companies that serve as their registered office wherever they want to be.
Okay. This is a popular question from both Yolanda and Marcus here. Can a series LLC be used on multiple properties? And I guess,
I'm sorry, can you say that again?
can a series LLC be used in the state of PA? And if so, would you recommend using it on multiple properties?
I'm not sure what you mean by a series LLC.
I'm not too sure either. That's what I'm seeing in the questions.
I don't know what a series LLC is.
Okay.
I mean, it's
Maybe
going to, could it say, can one LLC own multiple properties? Yes, absolutely.
Okay.
But I don't know what you mean by a series LLC.
Okay. Well, Marcus and Yolanda, maybe if you want to clarify what you mean by that, and I'll loop back around to that question. Taraya is asking here, what's the difference between an articles of corporation and operation agreement?
Articles of incorporation are for a corporation. It's what you use to form a corporation. Most people don't use corporations to own real estate because it has some tax disadvantages. So they own limited liability companies. Limited liability company is formed by what they call a certificate of organization. It is the same as an articles of incorporation in the corporate context. That's what the document that forms the LLC in Pennsylvania. But an LLC also requires an operating agreement. The operating agreement doesn't get filed with Harrisburg. It's an internal agreement, but it is something that is required for all LLCs to have an operating agreement. And it talks about the management of the entity. If you go to get a loan from a bank, quite often they're going to say, I want to see your operating agreement. Not that they want to read it, but they want to know that you have one. And as I said, you want to operate as an LLC that will prevent anybody from piercing the corporate veil. One of the things you do is you make sure, I always get a book, a corporate book or an LLC book, whatever you want to call it, for my entities. It shows that you have everything. Number one, it keeps you organized. Operating agreement will be in there. Your membership certificates will be in there. Your certificate of organization will be in there. And these are small things, but these are little points that show, yes, you're actually operating as a limited liability company. So that if anybody did try to pierce the corporate veil, it makes it next to impossible.
And Joyce is asking that, should these be documents that are notarized?
No, you don't need an operating agreement notarized. You don't need a certificate of organization notarized. Okay, none of that needs. In fact, typically, I sign as what they call the organizer. When I deal with a lot of people from Jumpstart, they say, well, I want to form an LLC. I say, here's my email. Email me, and I tell them the information I need. I prepare it. I said, when you're ready, you tell me, I'm ready to go. Let's go. I file a certificate of organization. They don't even need to sign it. The operating agreement, of course, they sign. All the members sign it. So I get it formed. I put the book together. You come in. I go through it with you. So you see, hey, here's the certificate of organization. Here's your tax ID number. here's your operating agreement. If you go into the bank, you bring this book, this is what they're going to want to see. Okay.
Okay, great. So give me a little bit of knowledge about naming your LLC. Does it need to have your company?
You can
Is
name
there?
it after your dog, it doesn't matter.
Okay,
It's funny, people just, they tear their hair out over that. It doesn't matter.
okay, great. So there's no advantage to naming
It
any.
would, it would matter, let me step back from that, okay? You can name it anything you want, but certainly you would want to name it something that if you're going to be doing, buying properties and putting that name on a legal document, an agreement of sale, you want something that's professional, okay? As opposed to, your dog's name, LLC. You certainly want something that is going to present the air of professionalism, so that if you're dealing with the bank, they see, you're dealing with Smith investors, or, Smith and Jones investors, or a lot of people, like, for example, Ken will often use the address of the property. Now, it might be the first property, because you might put a couple other properties in there. But you could say it's, Broad Street Investors, LLC. You certainly do want, and I think it's a good idea to have an air of professionalism in the name.
Okay, great. Stephanie is asking here, does an LLC need a manager? What is the purpose or benefit of
No.
having a manager? Can the manager be an officer in the LLC?
Doesn't need a manager. If you're going to have more than 2 members, then one of the things that is a good idea to put in the operating agreement of who's going to be what I call the tax manager. Who's the one that's going to make sure that all the documents get to the accountant, that the tax return gets signed, and things like that. That's a good idea. But you can have an everyday manager. You could say that, the 3 of us are 1/3 each, and Joe, he's going to manage the day-to-day activities. I'm the money man, I'm putting in some money, you're going to be here part-time, but Joe's going to be the one that's running the show. And you can actually put that in the operating agreement that Joe's going to be the manager for the day-to-day operations. But then you get back to, okay, that's the day-to-day operations. What about the more important or the bigger decisions? Do you want unanimous consent so that nobody can lock you out, and Joe and the other guy can't get together and say, hey, we're buying this piece of property. And you say, I don't want it. I think that's a stinky property. That's why you want to look at each situation and say, no, let's have unanimous consent for some of those big decisions.
Okay. Here's another question from Stephanie. Can a property that's not in an LLC be refinanced and the equity be put into an LLC?
Well, again, when you say, if it's not in an LLC, you don't want to take the money out and put it into an LLC. You could, you own the property. It's your money. If you want to contribute that to a new LLC that's buying a new property, of course you're entitled to do that. You can contribute whatever you want into the LLC. But what you can't, or what you can do, but you don't want to do, is transfer that property into the LLC, because now you're back to a transfer tax.
Okay. So there's a few leftover questions here, but did you want to continue on with anything you had planned to speak about, or do you just want me to keep going through these?
No, I'm done with the lecture portion. This is when, ask away.
All right, great. Joyce is asking, is the name of the LLC affected by doing business as a name? When people write checks, or if you have a building, does it need to be exact on advertising?
I'm not sure I understand the question. You can have an LLC is a protected name, okay? An LLC, like a corporation, if I was able to get, and I'm sure it's taken, but let's say if I was able to get, Broad Street Investors LLC, nobody else could use that name. It's a protected name, okay? So that Joe or whoever down the line a year later decides to try to form Broad Street Investors LLC, they can't, okay? The name is restricted. I own it. A doing business name is different. A doing business name, I could be Broad Street Investors LLC doing business as Upper Germantown Investors, okay? That's not, Upper Germantown Investors is not a protected name. So somebody else could go use Upper Germantown Investors, okay? That's not protected, whereas your LLC name is protected. But a doing business as name, you can have as many of them as you want. No, you're supposed to file them with Harrisburg. You're supposed to file any fictitious, what they call a fictitious name, and if it's going to be owned by your LLC, you're supposed to file it with Harrisburg.
Okay, so when a property is held within an LLC, can you refinance in your personal name without the transfer tax? Is there any way to do that?
Well, you can. Well, when you say refinancing your personal name, if the property is in an LLC, you can refinance it. The bank will be glad to refinance to that LLC, but the bank is going to require a personal guarantee unless that LLC has been around for a long time, and unless that LLC is papered up. They have a lot of equity. They own 5 buildings, and there's a gazillion dollars of equity sitting in that LLC. They're not loaning to the LLC based on the financial wherewithal of the LLC. They are loaning or refinancing based on the financial wherewithal of the members of that LLC. And they'll say, we'll be glad to refinance that property. But, you, Angela, and you, Derek, you're the members of the LLC, you're both going to personally guarantee.
Okay.
That's what they're lending in. That's what, when they look at the books and records, they're going to be looking at your personal books and records.
Okay. Laquan is looking to establish business credit, and they're wondering whether they should just create a regular LLC or a corporation for holding, which is better for establishing business.
I think it's not going to make a difference, but
okay.
As I said, most people do not use corporations for real estate investment. Okay, if you were going to open up a pizza parlor, then there's not going to be much of a difference between using a corporation or an LLC. Although I will be honest to you, if you go back, I would say about 10 years, maybe 12 years now, LLCs were a new advent, and people were still using what they called S corporations for most businesses. They weren't using them for real estate because there were tax disadvantages. They were using limited partnerships, which was a much more convoluted thing that you had to do. I have not done a limited partnership probably in about 12 years because you don't need them. When LLCs first came, as I said, they were new. No, but there were still some nuances from the tax point of view that hadn't been worked out, which had been worked out. There was still, people were a little nervous because there was not a great body of law as far as the liability protections that they afforded people that were, in business or real estate investment. That has changed over the last, 10, 12 years. I don't think I've done an S corporation. I think I did one about 3 or 4 years ago because the accountant was about 110 years old, and I don't think he was really up with what an LLC is. But from a credit point of view, it's not going to make a difference. I will tell you from an investment point of view, you're probably better off just using the LLC.
Okay. Donald is wondering, can you explain what a registered agent service is?
Registered agent is if you are forming an entity, even in Pennsylvania, if you don't have an address to use, there are services out there that are registered agents. They will serve as your agent. And the one I use is a company called N. Burkheim. And they will give you an address, but you have to have a hard address when you file in Pennsylvania. And they are there to accept service of process for you. Okay, that's the address that if I wanted to see the LLC, I can look it up on corporate bureau. I say, they're the registered agent, and I could see you, and they accept service of process for you. They accept the lawsuit for you. Most people will have, especially if you live in Pennsylvania, you don't have to pay them to do that because you have an address, whether it be your home or business, you have an address to use. If you decided to go into New Jersey, you decided to, or go into Florida, whatever, with the same Pennsylvania LLC, you are doing business in that state, and they're going to want you to have an address. And you say, well, I don't have an address in New Jersey or Florida. These companies, these registered agents, will serve as an agent in all 50 states. It doesn't make a difference.
Okay.
That's why they need an address, is so somebody can know where you are if they want to see you. I mean, that's really what it comes down to.
Right. And so I think I asked a similar question earlier, but Taraya's wondering if she partners with somebody and they both have established LLCs, can they partner with each other instead of naming each other as members under one LLC?
Sure. When you say partner with LLC 1 and LLC 2 can, be a partnership. They can work together. There's no problem with that.
Right. So that is doable instead of just, tagging
Yeah.
up one. Okay. Stefan is wondering if it is free to change the address of an LLC.
Is it free? Nothing that you file with Harrisburg is free. Okay.
All right.
That's first rule of thumb, but it's very inexpensive. I think it's like $7 or $10. It's very inexpensive to change. There's a form that you use to change an address, and
Is it difficult, or is it a fairly straightforward process? Or
oh yeah.
Okay.
Yeah. Again, if you go on to the corporate bureau, I haven't looked in a long time because I have these forms. I think you could find all the forms you need, and one of them would be change of registered address.
Okay. All right. So we have 3 more questions here, and then I think we're just over the hour mark. So we'll use these last 3 to wrap it up, and then you can have any closing remarks if you'd like. Marcus is wondering, he's looking to create a subsidiary in which the holding company will control and own the subsidiary LLCs. Do you see any issues arising if he does not place his personal name within any of the documents, operating agreement, certificate, or organization? He prefers that the parent company's name is used.
No, there's no problem. Anybody can be a member of an LLC, and it can be an entity. So if he has the entity formed, it's going to be the problem's going to come in as far as the bookkeeping and accounting nightmare. But if that's straightened away and you keep everything separate, no, that's fine.
Okay.
You can have an entity as a member of an LLC.
Okay. All right. And our last question here, it looks like, is from an anonymous attendee, but they're asking if they bought a multi-unit under a personal name with an owner-occupant mortgage, can they refinance it to an LLC name when they move out and rent out both to protect my other assets? Are there things that they should consider when doing this? Not sure if interest would increase.
Again, if it's in the individual name,
Mm-hmm.
any way, I don't care about refinance, any way you slice it, if you transfer that property into an LLC, you got a transfer tax. That's the key. You can refinance it just like as an individual. You can always refinance. But if you transfer it into an LLC, even if you own it 100% and you own 100% of the LLC, you got a transfer tax.
Okay. And sorry, I missed
Okay?
one.
Just let me add, it does, because I usually get this question. It doesn't matter if you say, well, I'll just transfer it for $1. The transfer tax is going to be based on the assessed value, not what the transfer, the consideration is in the agreement of sale.
Okay. And this is the real last one, I promise. Roger's asking.
I'm here. Doesn't matter.
Roger is asking, can Jeff, if you haven't gone over it, he was a little late getting on, go over the purchase of a property as an LLC with another family member who is not part of the LLC?
Well, it doesn't matter if they're a family member or not a family member. Mm-hmm. You're purchasing it with the LLC. This other person he can be a member of the LLC. Doesn't matter if he's a family member or not. But what you're not going to do is have LLC buy and him buy 50-50. It's defeating the purpose. He's got all the exposure there. Okay. I certainly wouldn't want to do that, but he could be a member of the LLC. You don't have to be family members to be members of the LLC. I'm not sure if that is the exact question that he's getting at. I'm not 100% sure. I don't know if you can follow up with him. and
Yeah,
get more
Roger,
clarification.
Roger, if you want to provide a little bit more specifics about your situation, you can, and I'll get to it. And there's a few more rolling in here, so we'll just keep going until maybe 10 more minutes if we have time.
Yeah.
Patrick is asking, if a property is sold to a family member for $1, could they buy that under an LLC? Could they then buy it under an LLC?
Sure, you can buy it under an LLC. Of course they could. Okay, they can form an LLC and buy it under an LLC, but what I just explained is if you sell it for, if I have a piece of property that Philadelphia is assessing at $100,000 and I sell it to somebody for $1, transfer tax is based on $100,000, not $1.
And just
That would be too easy.
and just for your sake, Roger said you answered his question well, so he's all good.
Okay.
Warren is wondering, is it a simple process to remove a person from an LLC who no longer wants to be part of it? And
yes, if he no longer wants to be part of it. Where the headache comes in is you got two people that are members of an LLC and they're butting heads. And there's nothing that requires, unless you have something specific, which is very, very rare in an operating agreement. Did I just lose anybody?
Oh, you're good. You're good.
Oh, okay. There's nothing that requires somebody to buy. There's nothing that requires somebody to sell. So I have a partner. He wants to go left. I want to go right. And there is no middle ground, and we can't work it out. The only thing you're going to be able to do is either one or the other buy out the other, or you liquidate the LLC. So if somebody just says, I want to get out and they want to let them out, absolutely easy.
Okay. Cool. Well, that's all the questions in the box there. So I think that's a good place to wrap it up. And I just want to go over what we have coming up here. Next week on the 27th, we're going to have First Impressions Lasting Impact, the Importance of Landscape and Residential Renovation with Sarah Endress. And the week after that, on August 3rd, we have Jumpstart and Philadelphia Housing Authority speaking on a new pilot program that we've been working pretty hard on. So with that, Jeff, you have any closing words here? I just, again, want to
just good luck, everybody. Remember, just be patient, do your legwork. Okay, you want to make mistakes. You want to make them early before you start, that's why you start small. Okay, so, but be patient. If the numbers don't work, realize there's a lot of deals out there. And so just keep a shrewd eye out there and you can do very well.
All right, great. As a reminder for everybody, if you go to jumpstartgermantown.com/JUMPinars, you can find a recording of all these webinars, and they're pretty easy to access. You just click on the media tab and JUMPinars, and they'll pop right up, including this one, which will be available tomorrow. So yeah, I think that's all we got. I'm gonna open up the chat now. So if anybody wants to do any networking or establish any connections, they can. But other than that, I think, Jeff, you're good to go. Thanks so much. Yeah, thanks so much for being a part here.
Take care.
All right. All right. Thanks again, everyone.
I'm going to put Jeff's contact info in the chat real quick. I did see that come up, and it'll also go out in the email that Derek's going to send tomorrow with a direct link to the recording. We'll also have that, but I'll put that up there.
And apologies for the microphone quality there. I think it was just a problem with his computer microphone, which it happens, but now we know to look for that next time. Oh, that was just to me, Angie, if you want to send that to all of them. right, and yeah, and like Angie said, we'll send that out in an email tomorrow morning, along with the link to the recording.
All right. Well, I think, yeah, we really appreciate everyone coming out. And my internet actually froze there at the very end, but I think Derek told everyone what was coming up in the next couple of weeks. So we're excited about those.
Just as a
Yep. And then we also, I don't know if anyone was here early in the summer, Alina DeLisser will be back. She was taking sort of a vacation, but she'll be back hosting in mid-August. So just wanted to let everyone know that she just took a little break. She's just doing this as a volunteer. So, but yeah, we really appreciate everyone tuning in. And yeah, we'll see you guys next Monday.
Sounds good. All right. See you later, everybody.